All right, Sergeant Brown, all our jurors present?
Yes, sir. Deputy Ham's here, that's it.
Okay, all right. Deputy Ham, can you check on our jurors, please? Mr. Steele, what can I do for you? Okay, all right.
Your Honor, just for a moment, there are some issues with the proposed exhibits. I don't know if the state's planning to introduce them today, but I just wanted to give you a heads up.
You're right, we're gonna pass them out, and I think we can deal with them after.
Okay, all right. She said you'll deal with it. She'll deal with them as they come, as they're introduced. So,
Everybody ready to?
all right. Summon our jurors, please.
Wait, no one, Your Honor.
All right, sir. All right, ladies and gentlemen, please be seated. All right, thank you, Deputy Ham. Ladies and gentlemen, the jury, good afternoon.
Good afternoon.
All right. Without further delay, we're going to go ahead and call the next witness. State.
Your Honor, Ms. Hilton calls Kenneth Copeland to the stand.
All right, summon Mr. Copeland, please.
Your Honor, here's that. Mr. Copeland is.
Just here it comes. All right, Mr. Copeland, go ahead and approach the witness stand. Before you sit down, if you would turn and face Deputy Hand and be sworn as a witness.
Raise your hand. You swear affirm testimony to everybody give report of the truth, the whole truth, nothing but the truth, help?
Yes.
You may be seated. Can you state your first and last name with the spelling of both, please?
You say that again?
State your first and last name with the spelling of both, please.
Kenneth Copeland.
Mr. Copeland, do me a favor. Pull your chair up as close as you can to the microphone and speak directly into it so we can all hear you. So if you could state and spell your first and last name for the record, please.
Kenneth Copeland.
Spell it, please.
KennethCopeland.
All right, thank you, sir. All right.
And Mr. Copeland, good afternoon. Do you want to be here?
Ma'am,
Do you want to be here?
I'm here.
Okay. Are you going to let me ask you some questions?
Okay.
How old are you?
Grown.
Okay, what does grown mean?
I'm an adult.
Okay. And when you say you're an adult, what number in years are you?
I plead the fifth.
Ladies and gentlemen, can I get you to step outside to your headquarters of jury deliberation, please? Room
jury.
All right, ladies and gentlemen, please be seated. Our jury has left us. Mr. Copeland, given the fact that you have invoked your Fifth Amendment privilege, but the state has already given you immunity under 24-5-507, this court holds you in willful contempt, and we'll see you on Monday. And we'll see if we can get some more testimony at that point in time. Take him into custody. All right. State, do you have any other witnesses you plan on calling this afternoon? No, Your Honor. Okay. What I'm going to do is I'll call our jury and tell them that you're going to be in recess for the weekend, and we'll come back on Monday.
And then, Your Honor, the jury is excused. Would you please entertain a motion for mistrial?
Mr. Steele, I'll entertain it right now.
I didn't want to hold the jury, but that'll be fine.
And what's the basis for your mistrial? We didn't know he was going to invoke. We didn't know what he was going to testify to, and I certainly didn't let him. He was only asked one question. So at this point in time, there's really, you can't knowingly let a witness invoke their Fifth Amendment privilege in front of a jury, but that didn't happen in this case. Last thing we heard from Mr. Colton was he was going to testify.
So everything you say, I'll adopt, because I was about to say those words. Based upon information belief, I'd like to call witnesses from the prosecution. I was told, I do not have the personal information, but I was told that Mr. Copeland made that known to officers of the prosecution team prior to being called right now.
But it's what I was told. The last thing the court knew, and he has counsel.
If a party knows that a witness is going to invoke the Fifth Amendment in front of a jury, which poisons us, there's no doubt it prejudices Mr. Williams et al., all of them, because this trial's been going on now, I believe, 8 months in front of a jury, and they've heard Mr. Copeland's name however many times a court reporter says.
Casey, that's what we've heard.
No, so the jurors have heard Kenneth Copeland.
And as well, okay.
I opened on him that he's a killer. We cross-examined all these witnesses about Kenneth Copeland. The state talked about Kenneth Copeland. My point is, if this honorable court finds that the state knew or had reason to believe that he was going to do this in front of a jury, that his response was going to be, I'm invoking the Fifth Amendment, then, Your Honor, yes, I adopt what you said. That's wrong of a party, and I'm moving for mistrial.
Okay.
Okay.
All right, sir. Thank you. All right. Yes, sir. It would apply to everyone. Yes, Ms. Love.
Your Honor, I'd just like to put some things on the record regarding Mr. Copeland. As we stated earlier, Mr. Copeland has...
I don't want to interrupt you. Your Honor, I'm just telling the court I am not accepting the proffer.
Your Honor, if I may...
Okay, but counsel gets the proffer, Mr. Steele. I can accept that. So could you sit down at this time, sir?
Sit down.
Okay, thank you, sir. All right, Ms. Love, you can complete your proffer at this point.
Your Honor, yes. Just to relate to the court the observations that members of our office have made throughout the course of this morning and throughout the time that we've been dealing with Mr. Copeland. Our cause for concern is Mr. Copeland's communication that he is going to us, that he is going to speak that he is going to speak on the stand, that he is going to testify, and watching what happens when Mr. Copeland gets on the stand. Mr. Copeland did not want to have to be taken into custody. The court gave him the opportunity to have present in court with him someone who is supposed to be representing his best interests. What we have seen is communication, both verbal and nonverbal, between Mr. Copeland's supposed counsel and counsel for defendants. And a look as if I tried from Mr. Copeland's supposed counsel in the direction of counsel for the defendants after Mr. Melnick attempted to assert for Mr. Copeland. May I finish?
Let her finish, Mr. Melnick. Please sit down. I'll let you start. Okay? All right. Thank you, sir.
While Mr. Copeland is on the stand stating that he wants to testify, that he will testify rather. So we are watching, and Mr. Melnick, I believe it may even be captured on film. The court can look at it. Mr. Melnick turns to the direction of counsel for the defendants and motions like, that's it. Then, upon information and belief, as we are standing out waiting for the jury to come in, Mr. Copeland requests to speak with counsel for the state, but Mr. Melnick keeps walking in. Then, as
Does he at any point in time tell you? Does he at any point in time tell you I'm not going to testify? I'm invoke the Fifth Amendment.
No. As what happens, as Mr. Copeland requested to speak with the state, Mr. Melnick keeps going in, regardless of Mr. Copeland's request to speak with the state. And then we learn that Mr. Melnick tells Mr. Copeland they are going to hammer you. So Ms. Hilton comes back in and asks me, had I spoken with Mr. Melnick? Had I told him that we are going to hammer Mr. Copeland? The state had not made any such communication with anybody. So what we are seeing, we believe, is tampering with witnesses, this particular witness on the part of people who are not the state. So we are concerned. I don't know that Mr. Copeland's interest is being represented when that interest may not be in alignment with the people that Mr. Melnick is communicating with on breaks, and after Mr. Copeland has communicated to this court, he will testify. So watching the goings on as Mr. Copeland is not on the stand, it has been publicized, it has been hyped up that Mr. Copeland is the next witness. Mr. Copeland is the witness. And then Mr. Copeland, he's been nothing but cordial. He's been nothing but communicative with Ms. Hilton during the time that she has been interviewing him and speaking with him. And the reason Ms. Hilton was not in here just now when the jury came out is that Mr. Copeland asked to speak with Ms. Hilton. But Mr. Melnick kept going back in there and going back in there and going back in there. And the reason that we have a problem with this is that Mr. Copeland is not facing any charges. For Mr. Melnick to suggest or say to him that we're going to hammer him, it causes us to call into question whose interest he's representing. And so we would ask that, you know, what I haven't even thought of in my mind an appropriate remedy at this point, because it is wrong for parties to inject themselves on behalf of purportedly one person. And I don't know. I guess they're, you know, I don't know what's going on. But I can say that this entire day, starting from the point at which Mr. Melnick is invoking Mr. Copeland's Fifth Amendment right after Mr. Copeland has said he's going to testify, has gone a little off rails, and it's a little bit concerning. So, Your Honor, as to this motion for a mistrial, we would argue that it's caused by actions on the part of people other than the state, that Mr. Copeland got here and said what he did. So we will continue to speak with Mr. Copeland because Mr. Copeland doesn't have any charges that are open. If he asks to speak with us, which he has, we'll go and speak with him. And I'm not even certain what is going on behind me with respect to persons who are purporting to represent the best interests of Mr. Copeland. But it would appear to me that Mr. Copeland's best interest would be served by Mr. Copeland not being inside the Fulton County Jail. But that's just my opinion. So, Your Honor, I would ask that the court deny the motion for a mistrial, at the very least, And if it goes any further, find that actions by people other than the state have led to us being where we are. Because Mr. Copeland was at the point right before lunch of agreeing to testify. That is the reason we were ready to get started right before lunch. Because now he's been told he's going to be hammered by his attorney, I guess. He told him that, I guess the state's going to hammer him. I don't even know what. But Ms. Hilton has gone over the questions that she has for Mr. Copeland. She has spoken with him about it. They have been speaking cordially with one another. And this idea that somehow someone is entitled to mistrial as a result of this action on the part of Mr. Copeland is a farce under these circumstances. We'd ask that the court deny the motion.
All right. I'm going to deny the motion for mistrial. Mr. Steele, at this point in time, I'll note that you've made it. And I'll let Mr. Melnick in just a second make whatever remarks he wants. Do you have anything else you want to say?
Yeah, I would like, but my understanding is, I'm going to proffer this, but there's a great investigator who is looking at me and I trust her. I'd like to call her to witness. I was told, I was not there. I was told that, I forget her name. I know her first name, but her last name. And Investigator Long, and I may be wrong, heard Mr. Copeland prior to coming in to the courtroom, almost immediately prior, state, and I'm reading from Mr. Kokomo, if I have to go to jail, then lock me up, and then the Honorable David Botts. The Honorable David Botts told me, as I was walking in, that he heard, he's right behind me, so he should be speaking for himself, but he heard Kenneth Copeland tell the prosecution, if I said the wrong people, please correct it, that he's invoking the Fifth. That's why I raised it. I'm not saying anybody did anything wrong. I'm saying that if a party knows or has a reason to believe that a witness may invoke the Fifth Amendment in front of a jury, we avoid that at all costs.
But the challenge we're having, Mr. Steele, is I do believe that there's probably been some behavior that probably wouldn't pass the good faith test of there's a lot of influences inside and outside. So I'm going to basically base it on the proffers of counsel and just remind you all of your professional responsibility requirements. Okay.
Well,
so
I'm going to remind it all the time because I live them. I'm just telling the court that in order for you to deny my motion for a this was bad.
And I'm going to deny your motion, and I've made my ruling. So I'm done at this point in time. Okay. In terms of this motion for mistrial.
Well, I'd like to call the witnesses, but I understand what you're saying.
I'm not going to call any witness. I don't need any witnesses. Your proffers are fine. Okay.
May I add a proffer, Your Honor?
Yes.
As you know, we are in a side room off the hallway on the first floor. That's where defense counsel, it's kind of their conference room. During lunch, I'm working on unrelated matters, and I'm going to get a ginger ale to calm my upset stomach, and I'm on the phone, but I'm hearing a gentleman speak very loudly on the phone with agents from the state. It's my belief agents from the state were present within earshot. And that gentleman on the phone, who was Kenneth Copeland, was making a...
How do you know it was on the phone? If it Kenneth Copeland's on the phone, was he talking on the phone or?
He's standing in the hallway 10 feet from me, practically screaming in the phone.
Oh, so Mr. Copeland's on the phone?
Yes.
Okay, and you're overhearing this particular
He's saying,
purported conversation.
I'm not testifying. I'm not giving a direct quote because I was on the phone handling my own business and I was having no interactions with...
Okay, but here's the thing. I think it's consistent with I'm not testifying. Okay, he can make a decision not to testify. Okay, but if he does so, and because he's already been told, look, you can invoke your Fifth Amendment privilege, and you've been given immunity, and if you don't, I told him what the consequences are this morning. That's consistent with what I've heard thus far, and I don't think that is.
I believe that the state was on notice that something like this was going to happen.
Okay, all right, but all of you have kind of, like I said, either unwittingly or I just remind you, from outside agitation or otherwise, you all need to stay away from any of this. You do. Both sides need to do this. Do not let outside influences, influence your actions and get you in trouble. You all should rise to a higher standard in terms of don't let any of this stuff. I mean, these witnesses will testify to whatever they're going to testify to. So
The defense has done nothing.
I didn't say you did anything wrong. Okay, but I did.
I've heard is that the state.
I didn't say you did anything wrong, but
I understand,
okay.
Your Honor, but I just want to be clear. The only thing that I've heard today is that the state met with Kenneth Copeland without his attorney.
Are we going back to that again? I thought we.
I don't know of any
Okay.
defense counsel that's had any conversations with Kenneth Copeland at all. And I just want to make that clear. Today, I don't know of anyone that's had conversations with.
Okay, but he's their witness at this point in time. If he wants to talk to you or he doesn't want to talk to you, he's got a lawyer, and that lawyer can make that decision, and so can Mr. Copeland. So
Situation because we have
I understand that, but you can't let other people, and I would advise you not to let third parties influence what you may think a witness is going to do.
That's not happening.
Okay, and that's all I was trying to tell you. Okay?
Okay.
All right.
Judge, I would like to hear.
Yes, sir. What does he like to tell me, Mr. Melnick?
Judge, I went back and reviewed my communications with the Fulton County District Attorney's Office in relation to Kenneth Copeland. And I found communications as late as June 5th of last year where the Fulton County District Attorney's Office had reached out to me about speaking to Mr. Copeland. Speaking to Mr. Copeland concerning this trial, not about any other case, speaking with Mr. Copeland about this trial. Neither of these attorneys, no attorney at this table has ever attempted to contact me about Mr. Copeland and about his willingness or desire to testify at this trial. They have put us in this position where at the last minute, I'm trying to advise him as best I can what I think is best for him. Had they exercised the slightest bit of professional conduct, we would not be sitting here having this conversation today. And unfortunately, for me to fully explain everything that's been going on, it would require me to reveal confidences that I'm not going to reveal.
I don't want you to do that, sir.
I can assure you that the decision to invoke the Fifth came completely from Kenneth Copeland. I owe nothing to anybody over here. I owe nothing to anybody at any of these tables. I don't care, candidly, no offense, don't care what happens with their cases. The only thing I care about is what happens to Kenneth Copeland. And for any assertion, I'm sorry, Judge, for any assertion.
And that's your primary duty.
It is. That's exactly right. And for an assertion to be made that I or Mr. Copeland are somehow being influenced by somebody over here is absolutely ridiculous. I take great offense to it, and I can tell Ms. Love that I am going to the state bar to report her for contacting a witness that she knows to be represented by counsel. She and I have had conversations about Kenneth Copeland.
Okay, and sir, that is whatever you decide to do outside of what the court is ruling upon. Remember, the court can only rule upon what I see. Okay, and what I see at this point in time is a witness who, for whatever reason, may have some other reasons about his testimony. He has expressed those this morning. He said, "I'm going to invoke my Fifth Amendment privilege." The state came to me and said, "Okay, listen, we would like you to sign an immunity order under 24-5-507. They make that decision. So there are. I mean, I think that gets us to the point where we knew that, or at some point in time, that the state knew that he was privileged. So
Absolutely knew it.
So, but in order. What we explained to your client this morning. So whether or not he wishes to go ahead and still invoke his privilege, that's his choice. But the statute's pretty clear.
I understand.
And I know you I've known you, sir, for at least two decades or more, sir. And I know that you have told him, hey, look, if you invoke, This is probably what's going to happen. And I suspect that if you probably have a conversation with him now, you're probably going to tell him, well, that was a self-fulfilling prophecy in terms of what I told you might happen. But I don't know what conversations you have with him, but I suspect that they were consistent with what the dictates of 24-5-507. Now, Monday, we'll go ahead and I'll call him out before the jury comes in on Monday morning, and we'll ask him whether or not he wishes to continue his testimony, because I don't want him to invoke in front of this jury if I can help it. So since he's made it once already, I'm going to ask him before the jury gets out here on Monday, is your intent to invoke your Fifth Amendment privilege? If it is, he's going to go back into custody until he's willing to go ahead and give testimony, because he has immunity, so he has to testify.
Judge, the only thing that I would say is that the primary reason Mr. Copeland is in custody right now is because the state has utterly failed to follow up with me in any regard with regard to what Mr. Copeland wants to do or intends to do.
I suspect that that's probably not true.
It is grossly unfair.
I've known you for almost 2 decades. I've known Ms. Hilton and Ms. Love in particular for a long period of time, and I don't think that they would do that to you.
Judge, at no point did they ever reach out to me about Mr. Copeland, about Mr. Copeland's testimony here today. The last time I heard from anybody in the Fulton DA's office was June of last year.
Ms. Hilton, did you reach out to Mr. Melnick? And if so, when?
When I talked to Mr. Copeland, he told me Mr. Melnick was not his attorney. So that is, I talked to the witness because
when did you talk to Mr. Copeland?
Last Friday, because my understanding prior to that is that Mr. Melnick had told Ms. Love that he wasn't his attorney. So when we went to go serve him, I understand that he did not have an attorney. When I met with Mr. Copeland, and this is Friday evening, Mr. Long and I went to go meet with him in the car. We said, hey, I think Mr. Melnick's your attorney. He said, Mr. Melnick is not my attorney. He said, I haven't even talked to him. And then that is when we proceeded to begin our conversations. Anytime that Mr. Copeland did not want to speak with us, we did not speak with him. We called him on Monday to see if he could come down here. He said he didn't want to come, or he didn't respond. We left it alone. On Tuesdays when we picked him up for the first time, on Tuesday when he did not take the stand, we went upstairs. We had some conversation. We left. Mr. Long took him back home, and then yesterday he came back down here with us. Again, we showed him some of the evidence that we were going to show him. And that was the extent of it. And if at any time Mr. Copeland would have told us he wanted his attorney present, we would have called Mr. Melnick. But our understanding was, one, he was not his attorney. Mr. Melnick disavowed being his attorney. And Mr. Copeland told me he wasn't his attorney. So that is what I based all of my decisions after. It was not until 6 o'clock last night, or whenever this email was sent from Mr. Melnick with Mr. Shard and Mr. Steele copied on it, that I get this idea that you've been talking to my client, and then my client is going to plead the Fifth, which brought us here today. That has been what has happened since last Friday, Your Honor.
All right. So we have a witness that may not have been totally candid, or may not have thought that he potentially needed you. And as things developed, Mr. Melnick, he decided, well, yeah, he does need you. But whether or not.
And Your Honor, it's my understanding that Mr. Melnick called Mr. Copeland last night. So it wasn't that Mr. Copeland called Mr. Melnick. Mr. Melnick so happens to call him the night before he's supposed to testify. So I don't know what has happened or what has transpired, but that is the extent of what occurred.
So I'm not going to get into my conversations with my client.
No, and I don't expect you to. But I do want to remind you, Mr. Melnick, as well as I reminded both sets of counsel, that you owe a higher duty of tribunal to me and the court than you do anybody else. So please don't, you as a professional advocate, don't put yourself in a position where you come cross purposes with the rules. Okay?
Of course.
And that sometimes has to be explained to witnesses and clients. Okay? All right. So that's where we are at this point in time. Is that Monday morning I will bring Mr. Copeland back out. It is, I don't relish the fact of holding him in contempt, but that's all I have at this point in time because he's been given immunity. So we'll take him up because that's our first session of court. We won't be having anything else until then.
And Your Honor, I would like to ask that the court convey to Mr. Melnick, to convey to Mr. Copeland that he is subject to being committed and held in the Fulton County Jail until the end of this trial. Because I'm certain Mr. Melnick, if Mr. Melnick wants to convey to us some of the concerns that he has, Mr. Melnick I'm certain is quite familiar with the statute under which the court has compelled Mr. Copeland to provide testimony. So there is nothing that we could do to Mr. Copeland regarding any testimony we elicit from him on the stand pursuant to the court's order under the statute that the court has cited, 245507. And that statute gives the court the ability and probably, depending on how the court feels about it, the absolute duty, given the necessity of Mr. Copeland's testimony, to hold Mr. Copeland in the Fulton County Jail until he decides to purge himself of the contempt of court by providing testimony. If Mr. Melnick would like to speak with Ms. Hilton or any other member of the state regarding his concerns about that order, which tracks the statute almost verbatim, then I would invite him to do so. Otherwise, as I've stated, I don't see it being in Mr. Copeland's best interest to be confined to the Fulton County Jail until the end of this trial. But I will leave those matters to Mr. Melnick, who at this time is asserting that he is representing Mr. Copeland. But again, that was not the understanding that Mr. Copeland had previously given to us.
All right. Okay, so Mr. Melnick, if you do in fact talk with Mr. Copeland, like I said, I'll bring him back on Monday and we'll see where we are at that point in time.
Okay.
And he has the ability to purge himself by just providing testimony consistent with what he knows or what his knowledge of is in this case, okay?
Judge, I have some personal matters that I need to convey to Chambers, but I'll do that off the record.
Okay, I'm going to recess in just a little bit, and but can you be back for Monday morning?
That's just it. I can't. Is this something I can take up off the record?
Well, I kind of have to call him on Monday. I do. I mean, there's no choice. I have no choice because that is the next session of court.
Judge, I have non-refundable tickets out of town on Monday. I can't be here. I cannot be here. And there is nothing I've had this on file with Fulton County since December 15th of last year. And again, had the state contacted me before today, I would have made them aware of this.
Well, there's one of those times as a lawyer that you're going to probably have to kind of figure out a solution, sir. I mean, I don't want to put you in this particular position.
I can't be here, Judge. I absolutely cannot be here.
Well, you have a choice. You can be here if you want, but you'll have to figure out some other things to do with your tickets. I mean, here's the thing. If you're asserting, if the state was relying upon the fact that you were not his counsel, and now you are, you have put us in a situation where now, you put yourself in between a rock and a hard place. I mean, so he's coming back on Monday.
I'll have somebody else make my announcement for me.
Then that can be done. And sir, I would advise you to do that. But remember, Mr. Copeland, has to have some concurrence. So maybe before he leaves and goes actually to the Fulton County Jail, you may need to have a conversation with him about that. So we're clear, and I'm clear as to whether or not you're coming back on Monday or somebody else is.
I'll have somebody here on Monday.
And I need to know who that lawyer is. Do you want to have a conversation with him before?
I'm going to talk to him right now.
All right. Okay. I'm going to allow you to do that, and then I'll remain and be available for a further discussion. So let me go ahead and Sergeant Ham, can you and your colleagues or Lieutenant Walker arrange for Mr. Melnick to talk with Mr. Copeland, please? All right. And I'm going to go ahead and at this point in time summon our jurors, please. All right. All right, thank you, Sergeant Ham. Promoted you already again. All right, okay. Ladies and gentlemen, jury, good afternoon. Okay, it appears that we have some more homework to do, and given the fact that that needs to occur, my suggestion is that we go ahead and recess you for the day, okay? And let you begin your Friday. Ladies and gentlemen, Monday being a regular work day, what I'm going to have you do is report for 8:30 for a 9 o'clock anticipated start time. And we'll see where the day leads us on Monday, okay? All right. Any ministerial inquiry with me, ladies and gentlemen? Anyone? Okay. All right. All right, unless you have anything of me, ladies and gentlemen, let's go through your admonitions at this point in time. Remember, leave your notepads in your headquarters, your jury deliberation room. Please don't take them with you. Remember that as you leave here and you gather, even outside our presence and hearing, to be in your headquarters, or as you go to whatever conveyance that takes you to your home within our great county, or if you're just in the halls eating or whatever, remember that it would be a violation for you to discuss this case amongst yourselves in ones and twos, or handicap the testimony, review the testimony, or otherwise give your thoughts or impressions about any witness that has testified thus far. Remember, you can only consider this case probably when the court gives you at a time and place instructions on how to do that. You cannot consider it in any way until such time as the court instructs you. Remember, it would also be a violation for you to add to your understanding, as I call it, meaning phone a friend, get a resource book, go to a website, or any other source that to aid you in anything that you've heard thus far in this courtroom. Remember, you can only consider what's been lawfully presented within the four walls of this courtroom. You cannot consider any outside sources, people, or otherwise reference materials to aid or augment your understanding. The other thing you cannot do is to go by any scenes that you may have heard about or may have been testified to in this case. You've been shown a bunch of maps and other audiovisual aids at this point in time. You are not to go by and visit any of those scenes. You're not to go by and take any pictures, do any sketches or anything like that, or share any other information you may know about those particular sites that you may have knowledge of. Remember, you can only consider what's been lawfully presented within this courtroom, okay? All right. Also, ladies and gentlemen, if any third party or would attempt to talk with you, reach out to you, email you, text you, or otherwise call you in any way to potentially reach out and communicate with you about this case, remember you to let myself and Sergeant Ingram know immediately. And then, ladies and gentlemen, and lastly is how we end most of our admonition sessions. You know, we are really appreciative of the patience and attention that you've given to this particular matter, and we'll continue to give to it. And we state that to you, and we ask that you every day we tell you this, but that is on behalf of all the parties here, ladies and gentlemen, we really appreciate your patience and attention that you have given and will continue to give to this to the consideration of this matter. All right, ladies and gentlemen, unless you have any other inquiry of me, we will talk with you on Monday at 8:30 and for an anticipated 9 o'clock start time, and then we'll see where the week leads us at that point in time, okay? All right, unless you have anything else, all rise.
Okay, ladies and gentlemen, our jury has left us. Please be seated. All right, anything else I need to take up with you all? I'm going to recess in place to allow Mr. Melnick to finish talking with Mr. Copeland and find out who is, if he or somebody else at his stead is going to be here on Monday. But if not, we will be here on Monday at 8:30. Any other things I need to consider?
Yes, Your Honor. There is a matter regarding the jail calls that we were provided. Mr. Steele has not yet provided us the ISO file. We received something additional on a thumb drive last night. We had the deputy of our jail call unit look at that, and we are again missing. We do not have the complete file.
To be able to play though?
To be able to access it properly, to be able to look at it, authenticate the calls, the time of day, all of that. We don't have it. We were provided last night a thumb drive with cut and pasted file names up under headings, with some additional pieces of a file that would have had to, again, have been deconstructed from the way that the file would have been given to counsel for defendant Williams. We are asking the court to compel defense counsel to turn over to the state the file in the original condition that it was given to them, so that we may properly access and evaluate the content and the time and date and all of that, and the authenticity of those calls on that file. It has been deconstructed, and particular parts of the file have been extracted and purposefully kept out of what is given to the state. So we are asking, again, that the court compel either, you know what? And if they don't want to, then we're asking that they just be excluded.
Okay. All right, Mr. Steele, do you have the raw file?
Judge Glanville,
Sir.
you allow another moment when Miss Love calls me that I did not do something. They have the exact image of what we got from the jail in Fayette County. That is it. And if I get another false allegation and you do nothing, I'm shocked. I'm appalled at you. I sit here day after day with this false allegation just machine. I gave the state everything. There's been no disconstruction. There's been no purposeful, I don't care. I don't care. I give over everything. I've done this for 33 years. Never in my life have I seen a trial. I've done 300 appeals in the state of Georgia alone. I've never read a case like this. Judge, I gave them everything I had. I waited. I was at my office till 8, after 8 last night. I waited for their investigator to come by. I handed him an exact copy of thumb drive. They have everything that we got from the Fayette County Jail. There's been no deconstruction. There's been no purposeful exclusion. This is not the first time.
Okay.
And I apologize that I'm getting tempered, but I've never been treated like this. You talk about professionalism every week. Professionalism is lacking with one lawyer here. It has never been. I don't even like coming to court. I used to love this. I would die for what we do. I used to say, I'm dying. I would die. I couldn't choose a better profession. If I had litigated with Miss Love, I would.
Your Honor, could we strike the
No,
hominem
I'm
attack?
speaking.
Really, could we strike that?
Okay, hey, everybody, calm down. Everybody,
This is me
both of you
false.
both of you, please be seated.
Judge, I'm not
Both
done.
of you, please be seated.
You have to do something. You have threatened me with contempt. You have threatened me with jail. If you go back in time, we can just start in voir dire. Jury after jury, you did individual voir dire painfully. Miss Love would come in and say that juror was crying. It was not true. You would say, that's not my recollection after I said it. You did nothing. We start
Okay,
the
but
case.
Mr. Steele.
I asked you, please.
Mr. Steele.
Please, Judge. How would you feel if you were being treated like
Mr.
this?
Steele. Mr.
Well,
Steele.
I'd like to finish.
Mr. Steele.
I gave them everything on that drive, and it's continual abuse of a prosecutor, of another member of the bar. I don't talk with Miss Love. And that's fine. I like that. But, Judge, I'm not going to stand here anymore. I don't care. You can take my bar card.
Mr. Steele, listen.
Wrong, though.
But there.
And Mr. Williams, you know, to me, This is an innocent man. You talking about, Ms. Love said there's a man in the Fulton County Jail. He shouldn't be there, Mr. Copeland. Mr. Williams shouldn't be in custody. But he's been charged, and we come here for a fair trial. It's been everything but that, according to Ms. Love has tried to demonize me. At times, Mr. Adams. At times, Mr. Shaw.
I object to
Now
the ad
it's
hominem
Mr.
attacks, and I ask for
all
restrictions.
because she wants to
Again,
win the
from the
case. And now she speaks over people. It's not right. I gave them everything. And by the way, and what I want to tell you, by the way, it's not even the law. If they call that gentleman on direct, I don't have to give them anything before trial. I do it because you asked me to. You said, listen, we got a big case. It's going to take a long time. Give them things. I gave this, by the way, to the state October of 2023. October 2023, that was uploaded, given to the state. I hear about it now, and I wait there, and I give them the exact duplicate of what we have, and now there's a false allegation of misconduct. And what I'm telling the court is what I said again. I do not appreciate it, and you have told it in front of the jury that I'm unprofessional. You were wrong. You based that on Miss Love's false representation.
Your Honor, again, the ad hominem attacks, Your Honor. I object, and he should stop talking when I
Ms. Love can
object.
try to silence me. Will not be silenced.
But Mr. Steele, here's the thing, okay? I think that, Mr. Steele, please be quiet at this point in time. You made your point. You made your point at this point in time. Both of you, please be seated. Please be seated, sir. Sir. Please be seated.
Whatever you do is fine, but I care about Jeffrey Williams. It's the best year.
Sir, it's obvious. I would expect no less because you're his advocate, you're his champion. But could you all please sit down so I can kind of figure out a solution for this? All right. First, let me just kind of address the obvious. I know that at times tempers have been heated in this particular trial, and they continue to do so. And I know that all of you are being zealous advocates and representing your clients to the best of your ability with zeal and rigor. However, I agree that, there should not be ad hominem attacks on anybody or any counsel, and that you all should think and reflect about what you say about your brothers and sisters of the bar. Because we have a large contingent of folks that watch this trial, and so not only for the purposes of this, but it sends not the message I think you want it to send. All right, so I'm going to leave you all to your wise discretion in order to do that, but and I'll take up whatever I need to take up as I see fit. But I know that you all. This has been a long trial. It's very demanding, exacting, and grating on, and tiring on all of you. So I ask you to just take a couple deep breaths and step back and kind of look at and just remember that you do represent of who you represent and what you're here for. In terms of the tape, or the phone calls from Fayette County. It's the court's suggestion that, and if you want my assistance, I can always, with a proper subpoena, have the raw, whatever it is that whatever you're seeking to get, I could get that, and you can compare that against what you have. Because maybe that's what, and Mr. Steele, I don't doubt, and I know that you would never delete or otherwise try and alter evidence, and I assume that that's what you got, and I'm gonna take that at face value. I'm in no way saying that. Ms. Love is in her argument is saying that she is, when it's stripped down, less all the sound and fury. She's saying that particular type of file has other things with it. I don't think you were given those. And that's what she's trying to get. So I'm in no way blaming anybody in this circumstance. But if you want that particular file, and I think you all should have that particular, the raw file, then let me do a notice to produce or a rule nisi, and maybe we can get the entirety of the file. And I think that if you did that, I think that the whole thing would probably be produced to you, because nobody probably wants to come down here and see me, So I will work with you all to get that, and you all can, we can take that up. And, it's a problem I think can be resolved, but I'm in no way, but I would just remind everybody to be careful about what they say to each other. Some things you just can't take back. And remember, y'all are going to see each other over and over and over again. And, you know, it serves you and serves the profession, serves your clients. It's not effective. So just please consider what I've just told you. All right. So, I'm just going to recess and we'll see where Mr. Melnick is at that point in time. And then we'll, I can talk about Monday for certain. Okay. All right. Okay. I'm just going to recess in place. All right. Collect your thoughts and please be seated. All right. Mr. Melnick, welcome back. The time is 2:35, I should say. Did you have an opportunity to talk with your client?
I did.
All right. Who is going to be here on Monday?
Kayla Bumpus,
Kayla Bumpus.
Bumpus.
Okay. All right.
And I can state, as Mr. Copeland's attorney of record, told him, are you sure this is what, asked him, are you sure this is what you want to do? And he said, yes, he intends to assert his Fifth Amendment privilege again on Monday.
Okay. Well, I will, if you would tell Ms. Bumpus she needs to be here at 8:30, and we will certainly take up with that knowledge, before we call our jury, and I will ask him, in her presence, whether or not he intends to do that, and we'll see where we go from there.
Okay.
Okay? All right. Anything else? Okay. All right. Sir, enjoy your time off, okay?
Thank you.
All right. Okay, counsel, is there anything else I need to cover with you before we recess until Monday?
Got it.
Yes, Mr. Botts. Mr. Botts, you need to use the microphone, sir.
Is it working now? Can you hear me fine?
Yes, sir.
All right. Your Honor, we started this whole fiasco out with whether the state knew that Mr. Copeland was going to take the Fifth Amendment when he took the stand. And if so, was that proper or improper to put him up on the stand knowing that they were going to...
You have to speak up, sir. If you could hold the microphone, it'd probably be better.
That he was going to assert the Fifth. And I know that they did know that he was going to take the Fifth because I heard it said outside right before I walked into court. I even said the officer...
Then why didn't you, as an officer of the court, tell me before we took his testimony?
I told Mr. Steele...
No. Why didn't you, as an officer of this court, tell me?
Well, then that's my...
I got a problem with you now.
Well, that's fine. I mean...
I got a problem with you now.
Well...
I would suggest you don't say any more.
I've already said it.
I know that, sir. And the problem is you should have told me. If that were your case, then you've just made an argument we didn't even need to have, because I could have certainly asked him based upon your proffer. Now you want to have it both ways. You can't do that.
Your Honor, I thought the state knew that,
And that's not what the point is. The point is, you as an advocate, you should have told me. Both sides have an equal responsibility under the rules of professional responsibility.
Okay, as long as we're both responsible, that's fine.
All right, have a seat, sir. Thank you.
Your Honor, I have a request of the court.
Is that okay?
No. What's your request, sir?
So in the attempt to avoid any spurious allegations moving forward, I would ask that Your Honor order that the deputies transport Mr. Copeland to the jail completely separate from any...
Yeah, thank you for reminding me of that. In our order, wait just 1 second. In the order of the incarceration, I'm going to, I also have a keep separate order for him.
Your Honor.
For the transportation and the housing, because none of these gentlemen are going to say anything to him, but I don't even want anyone to claim that
Okay.
he did.
I think that's fair enough, and that's a good suggestion. All right.
We'll prepare.
Yes, Lieutenant Walker. So that will not be an issue? Okay. Okay. But we'll go ahead and have him, if you could also have him housed separately too? Okay. Okay, thank you, madam. All right, anything else, councils? All right, take a couple deep breaths this weekend, take a knee, and come back on Monday and let's get after it again, okay? All right, we'll see you on Monday morning at 8:30, okay?
Can you get us the list of names and then any exhibits for Monday?
I think the only, I don't know who is being called. We can find out. Ms. Love and Ms. Hilton and Mr. Atkins, who is going to be called? Let's assume that Mr. Copeland invokes again.
Your Honor,
Do you have some other witnesses that we can take up at that point?
Your Honor, we will apprise after we look at and reevaluate where we are, because our order of proof was building blocks that at this point began with Mr. Copeland. And there are certain things that have to take place before we can tell them anything. So
Okay.
we
Fair
we have to do that. We have to deal with that and where we are right now.
All right.
And that's just where we are.
Okay. Well, be thinking about what scenarios you'd like to have the court look at.
Yes, Your Honor.
Depending upon whether or not Mr. Copeland decides he'd like to invoke his privilege again. Okay.
Yes, Your Honor.
All right.
And Your Honor, go ahead.
Madam.
Mr. Sharp, he can have the floor.
Yes.
I'm just going to ask a courtesy of the deputies, could we just keep our clients here for just 5 minutes after court ends, 15 minutes after court ends? The attorneys would like to have a discussion with our clients.
Lieutenant Walker.
And Your Honor, the state has a matter we need to take up ex parte with the
Okay. All right. Lieutenant Walker has been asked by defense counsels as a corporeal body for them to be able to talk with their clients once you clear the courtroom. Yes. Can you make that happen?
Yes.
Okay. All right. So once everybody is cleared the courtroom, you just secure it and let them be in here alone with their clients. Okay. Okay. Oh yeah. Once we go down.
Okay. Yeah. I'll make that happen.
Okay. All right. Okay.
One last thing, Your Honor. I just thought of this. Your Honor probably already thought of this. The no contact order with Mr. Copeland should probably also include not just these gentlemen, but other gentlemen that are on this indictment that are not sitting for trial. I think that would probably be. Okay.
Okay. All right. All right. Okay. We'll see you Monday. Okay. 8:30. We're in recess.